What exactly does good government look like? In practice, that's what the New Mexico Ethics Commission determines. The new body opened its doors this year after voters overwhelmingly approved the creation of the watchdog agency. It was decades in the making, but already has had to fight for its existence as lawmakers were slow to approve what the commission considered to be full funding for its first full year. Now, what's ahead? NMIF producer Matt Grubbs asked Executive Director Jeremy Ferris to come in for a conversation.
Jeremy Ferris, thanks for coming in. I appreciate it.
Well, thank you for inviting me. It's good to talk about the Ethics Commission.
Absolutely. Well, let's do some of the nuts and bolts stuff that we've been talking about. The Ethics Commission is 7 commissioners. Just explain, if you would, sort of how they find these positions and how they're selected.
Sure. So the governor appoints the chair. The chair has to be a retired judge. Then the legislature appoints 4 other commissioners. The leadership in both the Senate and the House on both sides of the aisle, both appoint a commissioner. So under the statute, the 4 legislatively appointed commissioners then appoint the final 2 commissioners. The commission has 3 Democratic appointees, 3 Republican appointees, and 1 independent.
Okay.
And that's important because a quorum for any commission action has to be conducted by the consent of 2 Democrats and 2 Republicans. That's part of what keeps commission action independent.
Can you explain to me sort of why an ethics commission is important for a healthy state government?
New Mexico is a little late to the game with the development and creation of an ethics commission. But in this instance, New Mexico's late mover status, I think, puts it in a strong position. New Mexico was able to learn from a lot of the early missteps in other states with the structure of an ethics commission. So one thing that New Mexico did, which was central, was doing this by constitutional amendment. The Ethics Commission is cemented into the Constitution, so it can't be undone by statute or by the governor's executive order as it maybe can in other states. And that's the foundation of the commission's independence. The statute is really well thought out as well, particularly with respect to the appointment of the commissioners. You know, they're appointed by different branches of government, by themselves. The appointment structure ensures that neither the governor nor the legislature nor either branch or party in the legislature can ever control the commission.
Is there a feeling amongst the commissioners and yourself as to how this should operate? I mean, are you sort of crusading looking for corruption like Elliot Ness? Are you sort of waiting for folks to file requests or complaints? How does this work best, and how is it working now?
So the crusading isn't beginning yet. I mean, the first thing the commission had to do, because our jurisdiction for the administrative complaints began on January the 1st. So the very first thing the commission had to do was set up the rules of procedure and the basic institutional capacity to handle administrative complaints that may be filed with the commission. So that's kind of like a junior varsity court system, where a complainant can file an administrative complaint against a respondent. Under the statute, the executive director ensures that the complaint is within the jurisdiction of the agency. If it is, the general counsel will determine after an investigation if there's probable cause. If there is probable cause to support the complaint, at that point, the complaint and all the materials are no longer confidential. They're made public, and the case is assigned to a hearing officer. The commission has a contract with former Supreme Court Justice Ed Chavez to serve as a hearing officer. And any appeals from a hearing go to the full commission. So that's kind of like the junior varsity court system.
Okay.
That, you know, and many administrative agencies have adjudicatory arms. In another way, the commission is also authorized to function as a kind of junior varsity attorney general for the statutes that are within the commission's jurisdiction, and the anti-donation clause of the Constitution, the one constitutional provision for which the commission has jurisdiction. And what I mean by that is the Ethics Commission is authorized to file civil court actions. So it's no, in that posture, it wouldn't be complainant versus respondent in the State Ethics Commission. It would be State Ethics Commission as the plaintiff versus a defendant in state court.
Okay.
And so that might get to the Elliott Ness crusading comment that you made. But for that, the Commission needs to put together a policy which will guide determinations from an initial assessment to an investigation to the Commission's authorization of a civil court action. And that's important because this can never be designed in a way to where it could be empowered to be a political witch hunt in anybody's hands. So we need to put all of the policies and all of the rules and the regulations in the administrative code to ensure that the Commission's decisions are always ones that are based on the facts, on the investigation, and aren't politically motivated. And so the Commission still has to do that policy-making piece before it can properly think about filing civil court actions. But that's part of the institution building that the Commission has to do.
Okay. I want to get to sort of a series of firsts for the Commission. One of them is, though, that you have filed in a court case involving former Secretary of Taxation and Revenue, Demasio Padilla, asking an appellate court to, is it reinstate some of the charges that were dismissed?
Not precisely.
Okay.
So Ms. Padilla's case, part of the counts in the Attorney General's second amended criminal information are pending appeal with the Court of Appeals. And those counts are counts in which the state brought criminal enforcement actions for a certain provision of the Governmental Conduct Act under Section 1016(3). In the district court held that those provisions of the Governmental Conduct Act are not enforceable. They're not criminally enforceable. And Ms. Padilla has argued in her papers that her attorneys have argued that they're not enforceable because they're impermissibly vague. The language in that part of the statute, according to Ms. Padilla, is that, and the court so found, the district court so found, was that the language is too vague to be constitutionally enforceable. And the judge dismissed those accounts, and the Attorney General appealed that dismissal, and it's now pending in the Court of Appeals. Ms. Padilla's case is the fourth in a line of cases about that particular provision of the Governmental Conduct Act, 1016(3). And all of those cases are currently pending in the Court of Appeals. What the Ethics Commission did was file a motion for leave to participate as an amicus curiae, as a friend of the court. And the Ethics Commission filed an amicus brief in which the Commission argued that provision of the Governmental Conduct Act creates real enforceable duties. That provision of the Governmental Conduct Act applies to legislators, state employees, public employees, and state officials and public officials. And it prohibits those persons, legislators, public officials, public employees, from using the resources of public office to pursue a private interest only, or from abusing their office while in public service, or from not disclosing conflicts of interest. The Ethics Commission believes that provision in the Governmental Conduct Act is really central. It's one of the few that applies to legislators, and it's the Ethics Commission's view that the language in that statute creates real enforceable duties under the Governmental Conduct Act, and they're not so vague as to be unenforceable.
You've also issued your first advisory opinion. This is a case in which someone came to you, and at least my understanding of the advisory opinion is that the Commission found that it needs some specificity when it's getting asked to issue an advisory opinion on some things. Can you explain that a little bit to me?
Right. That's almost right, Matt.
Okay.
So
you tell which one of us is the attorney. Right?
You are right that requesters for advisory opinions, they have to be within the jurisdiction of the Commission. Not just anyone can request an advisory opinion of the Commission. We don't provide free legal advice to everybody.
Right.
But legislators, state employees, candidates, lobbyists, employers, those that are subject to the procurement code, those that are bidding on invitations to bid or responding to requests for proposals, that universe of people which is about 45 to 50,000 people within the Commission's jurisdiction. Anyone in that universe can request an advisory opinion from the Commission. And the Commission will issue advisory opinions as to whether or not a specific kind of the factual predicates in the request violate, a law that the request asks about. So for the first request asked whether a state employee who's working for the state, if that state employee is also receiving a salary from a political organization or a political campaign committee, does the receipt of that salary violate, and the request kind of listed a number of acts that the Commission has jurisdiction over. Does it violate the Governmental Conduct Act? Does it violate the Gift Act, Financial Disclosure Act, et cetera? Just the mere fact of a state employee receiving a salary from a political campaign, that alone, those facts alone don't establish a violation of the law. What was more or less the answer that the advisory opinion gave? The abandonment of duty statute that the state has contemplates that state employees can have other jobs. And that doesn't change if the other job is working for a campaign committee. So for example, there's no violation if a state employee in the evening, does graphic design work for a political campaign. That's not a violation of the law. And so the advisory opinion kind of rightly answered the question. No, it's that those mere facts don't establish a violation of the law. The advisory opinion did point out provisions of the laws that might be implicated. I mean, it can't be the case that a state employee uses the resources in their state office to work for a political campaign committee while they're at work, nor can a state employee take some action in exchange for payment from an official action in exchange for payment from a political campaign committee. But that's just kind of signaling like the context, the legal context in which the question is situated. But what's really going on is that the Commission will focus very clearly on what the request is and what the factual postulates in the request are, and the Commission's answers are going to be tailored to specifically what the question is. The Commission can't be in the business of guessing at what the requester might be getting at from what's going on, what perhaps is going on in newspaper reports.
Sure.
The Commission's opinions are going to be tailored to the facts that are presented in the request.
We're almost out of time. I will ask you to stick around and talk with us afterwards, and we'll put it up online, about sort of this idea of taking a look at state official salaries, things like that. But the last thing I want to get to for our on-air part is talking about the complaint that you received. I know that there's a system in place that protects the people who file those complaints. One of the things that I saw as I looked at the Ethics Commission's website is you are creating a system through which people can actually follow their complaints in a confidential manner. You've created a system by which they can file a complaint online already. The complaint that you've gotten, what is the process for that as it moves forward?
So for any complaint that we receive, all the materials and the decisions that relate to complaints are confidential up until the point the General Counsel makes a probable cause determination and the complaint is kind of given over to a hearing officer for a hearing. But for any complaint, when a complaint's filed, the respondent has an opportunity to respond, to file a motion to dismiss for lack of jurisdiction or another appropriate motion. The respondent can have an attorney, so as can the complainant. All of those materials, the executive director under the statute first reviews to determine if there's jurisdiction. If there's jurisdiction for the complaint, then the General Counsel begins an investigation into the facts through interviews. We can go and ask for a subpoena. If the complaint is supported by probable cause, if the General Counsel believes that there's enough in it to think that the complaint's supported by probable cause, then it goes over to a hearing. There will be a public hearing, and then from a public hearing, there's an appeal to the full commission. That's the rough procedure for complaints. We are building an online electronic filing system, case management system. That'll be fully operational later this fiscal year, later this summer. But the rules of procedure are in place. They're in the New Mexico Administrative Code 1.8.3, and that's what governs the adjudication of complaints.
Okay. Well, Jeremy Ferris, thanks for coming in and spending some time with us. We appreciate it.
Thank you.